will be on Facebook in addition to this Zoom webinar. Perfect. Okay. Think we're ready to go. Everyone on the panel, good to go as well? Okay, let's get the party started. Ladies and gentlemen, Daniel Fruzen, president of the Westside Bar Association. So happy to be here on what I think is a rather unique evening. It's not every day that you get to meet the executive director of the state bar, the organization that licenses you, and get to have a one-on-one or one-on-two or whatever format we're going to do here, conversation to go over topics that are clearly important to all of us, topics that are important to the state bar, topics that are important to individual attorneys. And I'm excited because there's a lot to talk about. There's a lot of changes in the world. We have artificial intelligence. We have ChatGPT. I'm beginning to see legal resources that use artificial intelligence. In addition to that, of course, there's always the paraprofessionals, the sandbox, non-lawyer ownership of law firms. So much stuff to discuss. So very glad to be here. Ms. Wilson, thank you for joining us tonight. How are you doing?
I'm doing well. And we do have a presentation to share. So I see screen sharing is disabled for now, so hopefully. And we did try, Daniel, to accommodate what you indicated folks would be interested in. So I hope that this is not too long. We're going to have a kind of a deck that goes over some of the key, I think, hot topics in regulatory reform, in the regulatory reform space, paraprofessionals, and then legal tech. And we're going to give a little bit also of an overview of what's happening in other states and abroad, and then open it up for Q&A. So hopefully that works for you. If at any point it's not working, just jump in and let me know, okay?
Go for it. If I think there's something I think the audience wants to hear about, I'll jump in and pause you. Is that okay?
Yes, that sounds
Beautiful.
great.
Okay.
So let me find the presentation, which is now lost in my many screens. All right, so go ahead and get started. So as I said, I already gave you kind of an overview of what we plan to cover. And I'm going to turn right away to Jennifer. Go ahead, Jennifer.
Thanks, Leah. What is legal regulatory reform? It is reducing unnecessary requirements to safely increase innovation and access. Mechanisms can include changes to unlawful practice of law rules or non-attorney ownership and fee sharing rules, which is sometimes referred to as alternative business structures. We can also think of legal regulatory reform as either people-centered to expand the number of individuals authorized to practice law, or tech-centered, which involves harnessing tech innovations to help lawyers practice law more efficiently or to replace some functions of legal professionals. Next slide, please. So what is a legal paraprofessional? Legal paraprofessionals are licensed and regulated professionals who can provide legal advice. Unlike lawyers, they cannot practice all types or areas of law. Rather, they work in authorized practice areas for which they are licensed and with a designated scope of practice for each practice area. For example, a legal paraprofessional may be licensed to practice in housing law, but this may be limited to simple landlord-tenant, unlawful detainer, and housing vouchers. Next slide, please. Legal paraprofessionals must undergo training before they become licensed to practice. Paraprofessional programs typically include educational requirements, which can be coursework, a certificate, or a degree, supervised experiential learning for a specific number of hours, and there are usually requirements related to practice areas. And additionally, there's testing by subject area and moral character determination similar to that of lawyers. Legal paraprofessionals are also subject to ongoing regulation, which may include bonding requirements, disciplinary oversight, and continuing education. Again, paraprofessionals typically only practice in designated areas of the law and provide limited legal services. And they typically charge lower fees than lawyers, making their services more accessible to many modest means individuals who do not qualify for legal aid, but who could not otherwise afford legal help.
So
And now,
if I can hop in and pause right
Mhm.
here, guys, are we planning on going through all 48 slides?
Yes, about at this pace. So we cannot too. It's totally up to you.
Look, as I understood it, we were going to have more of an interview because a lot of these things that we're going over, and I'm sure we'll go in more depth as you go into these slides. But I think I know what people want to ask. And I think I'd be really bad at my job if I didn't ask the questions. I'm going to start getting text messages on my phone if I don't.
Go ahead, ask.
But I also don't want to take away. I can tell you put some time into this. It's 50 slides long.
That's fine. That's fine. I think we're totally open. And why don't you ask a question? And if there's slide content that's relevant, we can pop it up.
Okay, so yeah, let's just start big picture. Let's just start paraprofessional program. And I think part of the confusion here is not everyone understands what the goals are. So Ms. Wilson, if I was to say to you, what is the goal of the paraprofessional program? What would you say?
Okay, so I'm going to say what the goal is of legal paraprofessionals. Of course, there is not a program in California today, but the goal is to increase access to legal advice and representation for people who will not qualify for free legal aid, yet cannot afford a market rate attorney. That's the goal.
Okay, and I think that's very reasonable. Are there any areas of the law in particular that you think paraprofessionals would be the most worthwhile for the public?
Yes, and for that, I will pop up a slide because these are the areas of the law that informed the development of the paraprofessional program, although not all of these were included. So you can see here, number one is health. This is accessing your rights related to your health insurance, or you have denials of various benefits. That's the number one area. And these are color coded by those who above and below that line that qualify for free legal services. Finance, consumer finances, collections, employment, lots of issues in employment, wage and hour, and getting your Department of Labor judgments enforced. Income maintenance, these are all your benefits. This as well is often administrative agency proceedings. Family law, housing, and wills and estates. I will say that for California, the program that we try to advance that we are unable to includes all of these topics, but not wills and estates, the California program.
Okay, so let me have a follow-up question here because I think this is where the confusion starts. And by the way, ladies and gentlemen who are listening, I've been on the calls with the state bar. I've heard other attorneys. As a president of the organization, I've certainly heard people complain. I've heard various things. So this is an opportunity to really get to the devil's in the details. I was brought under the understanding, and correct me if I'm wrong, Ms. Wilson or Ms. Selnick, I was under the impression that paraprofessionals would be allowed to practice all areas of law, for example, including personal injury. Is that not true?
No, you mean the California proposal?
Yes.
No, the California proposal never included personal injury. In fact, it was specifically excluded. So again, I'll just pop these up here to show you what was included. These were the included practice areas and these sort of sub areas within the included practice area that were identified for inclusion in the California paraprofessional program. So you see family, children in custody, you see what's included, housing, collateral criminal, expungements, reclassification of convictions and infractions, consumer debt and general civil, these actions only, income maintenance, this again is your administrative agency proceedings. So that's what was included. And there are specific things, I don't have it in this deck, that were excluded. For example, in family and children, there are certain things that are explicitly excluded. I think it's the ERISA calculation, is certain sort of more complex areas of family law were excluded. So this is it for the recommended practice areas.
Okay, interesting. So off the bat, that's a big deal to me. Because I was brought to understand, and maybe I was listening to the wrong sources, but I have a feeling I'm listening to the same things other people are listening to as well. But as I was brought to understand it, this is effectively sort of a quasi-lawyer position where they're allowed to do everything up until trial. And I do know the terminology up until trial is on the paraprofessional page on the California State Bar website. And to be clear, ladies and gentlemen, when I say paraprofessionals, it's been put on pause. So I'm referencing a program that was going forward and now is on pause, or I don't know if it's been eliminated altogether. But what I'm hearing here, Ms. Wilson, is the idea here was never to allow these people to do what lawyers do, to file a lawsuit. It seems like it's more individual items that have been specified by the state bar where there's a sense that there is an increased need for access to justice. Is that fair to say?
I think I would modify that characterization. I think for the identified practice areas, for most of them, there is an intention to have the paraprofessional be able to fully represent the client. Now, there are some areas, and again, I don't have it in the deck, this level of specificity, but I could find it, where like in consumer debt, for example, you cannot represent somebody in court with the paraprofessional. They could only deal with negotiations with the collections agency. So there are limitations in certain areas that I would say, yes, you're accurate. It's not everything a lawyer can do. In others, like dissolution, you can do everything a lawyer can do, other than those excluded categories, like sort of the very high value retirement account transactions. So that I would modify your answer to say, within the limited scope of the authorized practice areas and sub-practice areas, there is an ability to do most of what a lawyer can do.
Okay, so I practice personal injury and employment. It sounds like, and I do abuse as well, but it sounds like personal injury is completely excluded. Is that fair to say?
Yes.
Okay, so let me hop off that. Let me hop onto the employment. And I saw on the deck that you just put up there that it looked like labor law may have been included to some extent. So at least let me talk about employment, because that's an area that I know about and I can ask some questions. Is the imagined use of the paraprofessional program as it was initially designed to allow the paraprofessional to file a lawsuit for example, wage theft?
Well, not to file a lawsuit, no, only to be able to enforce a judgment that was awarded through like the DLSC, I believe it's called. So if you got a judgment in that administrative agency proceeding, and we know, right, there's a lot of data that suggests that those judgments are not enforced, you could bring an action to enforce a judgment. So that's the limit, that's the limitation there. So it's not sort of just going out and suing an employer. It's enforcement of a judgment awarded by an administrative agency.
Okay, is there? I'm looking for the controversy here. I'm not quite finding it. Is there? And maybe there is none. Maybe it's just completely miscommunication, which again just makes me happy that we're here tonight. Is there a point at which, in your opinion, and we'll stick to labor law and wage theft, is there a point at which the paraprofessional's ability begins to mesh with or override or overlap with the lawyers outside of things like enforcing administrative judgments? You're saying they can't even file lawsuits. So that sounds like a hard stop right there. Am I missing something?
Well, I don't think you are, but I also, it's been a long time since I have gone into the weeds on all of the practice areas. And so I really want to see like what I can find. But yeah, it's wage and hour proceedings and judgment enforcement. Wage and hour I'm looking at a different deck. Wage and hour proceedings in the administrative agency setting and judgment enforcement in the Superior Court. That's what's authorized. Unemployment insurance proceedings and public benefits proceedings. That's all that was authorized. So I have to say, in general, the opposition to this was difficult for many of us to understand, because it is very limited, the areas that are allowed. So I think I'll share another slide. Sorry, we're just dancing around here, but this is kind of fun for me. keeping me on my toes.
Oh, please, I feel bad asking. you
Although
guys-
we're seeing
slides.
a black screen and I'm not sure why. Okay, are you seeing this? All right, so let me just present it though. Or maybe that's where the problem lies. I can't present it. All right, so you'll just have to see. Oh, here we go. So for example, representation in court, like the other deck doesn't have all this detail because it was only 48 slides, which you thought was too many. So here, representation in court, except for jury trials, paraprofessionals can provide full in-court representation subject to practice area modifications. So over here in general civil is where you have employment. So consumer debt and creditor harassment, all superior court litigation excluded. So what they can do is enforce a judgment in superior court. That's the action they can bring. That's all they can do under general civil. Consumer debt and creditor harassment, they can't be in court at all. You see the limitations, family, children in custody, and you see in housing, it's limited to in-court support for unlawful detainer, bench, or jury trial. So you can't argue, but you can sit here at the counsel table. So there's a lot of nuance to the proposal, but no, in no sense can they do everything a lawyer can do because lawyers have none of these exclusions at all.
It's interesting if we can leave that slide up for a moment. By the way, the slides are, again, I feel bad. I'm asking you to go away from these slides you clearly put so much time into, so I'm happy.
No, this is an old deck. This is November of, I don't know when. I'm going through the archives to answer your questions.
Okay.
Yeah.
Okay, I feel less bad now. Fantastic. Okay. Look at this. This is an interesting thing because as I somewhat envisioned the way tonight would go, one of the examples that I would give for a paraprofessional thing that makes the most sense to me. Imagine, let's just say we're going to be a little bit general and you know, a little. Imagine a single mother who's the victim of domestic abuse. Let's just say English isn't her first language, comes from another country, isn't really financially well off or independent from her husband, and she's in a horrible situation, and she may not have the ability to get out of it because of a lack of knowledge, a lack of finances, whatever it may be. And I always thought to myself, good Lord, that sounds so ideal for the notion of a paraprofessional. And I always thought that's a direction something like this should go into, not in the direction of literally taking over the job of a lawyer. And as you show me this deck, in the very middle of it, domestic violence hearings involving children, it's children limited to in-court support probation. Either way, it sounds like, so let's ask the question a different way. These items that you guys came up with that you want the paraprofessionals to handle, how did you get to those? How do we get to consumer debt and general civil, housing, family, children in custody, and the subcategories? What was the impetus for these items in particular?
Okay, so the impetus was first and foremost the Justice Gap study, California Justice Gap study completed in 2019. So as I mentioned, or I showed you previously, the slide that showed the most high need practice areas, that data came straight from a survey, and we had, I don't remember how many, but it was a representative sample done through the University of Chicago Research Center. So it was a very reputable study. It identified the key need areas. Then what happened is the Board of Trustees established a paraprofessional working group. It was chaired by an appellate justice from the First District and had representatives both from the trade, the bar trade associations, legal services organizations, and others that were on this working group. I have plenty of slides that go over that as well. The working group met for nearly 2 years. I think it had over 130 meetings between the working group itself and the various subcommittees. And what they did is they went in their first meeting, how are we going to tackle the practice area question? It's practice area and scope of practice. What can you do in what practice areas? So they reviewed the Justice Gap data. They reviewed Superior Court data on the incidents of self-represented litigants. They reviewed what's available through the legal services market for free with no income limitations. And very importantly, health is one of those categories. They reviewed the California practice analysis, which was a study done to support or improve the bar exam. And that tells you the level of complexity of various practice areas. So for example, You're never going to see constitutional law in a paraprofessional program. That is ranked as highly complex. Okay, so they did a number of things like this, and they also heard a lot from various practitioners, clients, potential clients, paraprofessionals in other states, judges in the state of Washington that have paraprofessionals appear before them. A very extensive process, and you get to the practice areas and the limitations on scope that you see in these various slides I'm flipping between.
Okay, so it sounds like you guys didn't put a lot of work into it at all, right? And that's me being sarcastic if that's not obvious. It is interesting to me, the disconnect between what I'm hearing now and what I've heard before. My brain keeps saying, well, Daniel, keep asking more questions. Aren't they taking over lawyers' jobs? Aren't they making the law license unnecessary, so on and so forth? Am I, as a community, and I hear a lot of people complaining about things like this. As a community, would you say there's a disconnect between what you guys are intending and what the community thinks you're doing?
I would say yes. Can you hear me? I feel like my internet is.
We can hear you.
All right. I would say yes. And I think as Jennifer's exploring this more and certainly has a really good grasp on what's happening in other states, I think she would agree with me. It's been really confusing to me, the level of opposition, because there is so clearly, we did an estimate, 2 million Californians 18 or over with at least one civil legal need that is currently not being met. We have that data from the Justice Gap study. They won't qualify for free services and they are not able to afford an hourly rate attorney. And I have a slide for that as well, but it basically, we show that at the average California income of $75,000 a year, it will take you 10 hours of work to pay for 1 hour of an attorney using the Clio data, average hourly rate charged in California. So the math does not add up for a moderate income individual. So these are folks who are not in the market. They are not competing for lawyer services. They're choosing to stay in the sidelines. That's the group that the paraprofessional would target. Now, do I think that attorneys that probably from a business perspective also want to figure out how to target that middle market? Yes. But right now they're not getting served at all. So I think there's a tremendous disconnect, and I'm sure we take some responsibility for it. I think there has been some protectionism and sort of fear that's also driven a bit of the narrative around these initiatives.
Yeah, I can tell you that with just my finger on the pulse of at least a constituency of the WBA, but honestly, I go to so many bar association events. I speak to so many people. I get a degree at least of the zeitgeist, and sometimes I get the feeling the constituents of the state bar don't feel like the state bar has their best interest at hand. I'm not necessarily endorsing that myself by any means. And I should actually point out, ladies and gentlemen, the way this came to fruition is me and Ms. Wilson got on the phone. And I said, so generally, I didn't say it exactly like this, but more or less like this. I said, so the paraprofessionals are going to be allowed under the initial proposal to represent anyone as if they were a lawyer up until trial. And her response was no. And then there was a period. And then I was like, wait a minute. This sounds a little different than what I expected. So I think that's why we're reaching this place where it's good to have this communication. And I think what you see, for example, is with stuff like the CTAP, which the majority of the CTAP is stuff that was already there from my understanding. Now, in addition to that, it does seem like the CTAP has some things, and we could talk about them. There's actually an interesting item in the CTAP that might be worth speaking about. But there is, for example, additional steps and bureaucracies, and it avails lawyers to a situation where they are now more likely maybe more likely to get audited or whatnot, based on the shortcomings of another lawyer who all of us decry, Mr. Girardi. And so I think that created a little bit of a mindset, and that's one example. I'm not saying that's the entirety of it. And again, I'm not personally endorsing that viewpoint. What I'm trying to do is I'm trying to open that line of communication as an exemplar of the constituency of the state bar who hears what these people have to say and figure out why it is that we're at this place. So let me further this conversation by asking you this. So let's say the paraprofessionals take these individual, rather compartmentalized categories of work. Is there a way, is there an absolute list of the positions they can take, like I looked on the website, on the State Bar's website, there's certainly a list there, but it's not as detailed as the list you just showed us, for example. Is there a list that would indicate to the constituency, so I can go to the WBA and say, hey guys, look, these are the actual areas that they intended paraprofessionals to practice with limitations? Is there an official public list?
Yeah, there is. I can try to find it right now, but yes, the answer is yes.
Okay, so I have a question here. It's from Marianne Gallagher, so I want to put this out there. She asked, would you guys be willing to share that PowerPoint? I open it to you. Is that something that we could publicize to our constituents?
Yeah, we can ask her which one. I think I'm showing you guys three. The original one prepared for tonight, or I have many, but yeah, absolutely.
Okay, so that's something. And look, what my goal here is to facilitate this conversation between the State Bar and at least the WBA members. So anything I can give these guys that would shine light on the circumstances, I think it's worth it. And ladies and gentlemen, you're hearing it from the executive director of the State Bar. You know, there's no, the information is not watered down. We're getting it straight from the source, which is amazing to me. What about enforcement? What about ethics and oversight? How is that imagined?
So that was fully articulated in the proposal. Let me see if I can go to that slide. Okay. Interesting when all right, it just takes a long time to load. So these are the recommendations around what I would call regulation. So these are the California recommendations. Surety bond. This, of course, attorneys are not required to have malpractice insurance or a bond. These folks were going to be required to have a $100,000 bond and to contribute to their own client security fund. The MCLE requirement is parallel to the requirement for legal specialists. As you know, the rest of us that aren't specialists, it's 25 hours every 3 years. If you're a specialist, it's 36 hours every 3 years. So this was a 36-hour requirement. Also important here is the fees charged to clients was going to be a required reporting indicator, meaning paraprofessionals were going to have to report the fees they charge to clients. This is very important because the goal is to provide a service that is lower cost than a market rate attorney. So obviously, if they're not, then we really aren't achieving the policy goal. So let me see. This next is rules of professional conduct. Important to highlight that there was a fully articulated rules proposal that also came with the paraprofessional program recommendations. And it included this informed consent, basically in multiple ways and places, telling consumers, I am not a lawyer and there are limitations on what I can do. Fee sharing was not allowed. The original proposal did allow co-ownership with lawyers. This is an old deck, so this actually changed.
Can we actually pause on that? Because I know I'm going to get questions. The co-ownership with lawyers, or I should just say the non-lawyer ownership of law firms, was that the sandbox, or is that something that came in through paraprofessional?
That was recommended as part of the paraprofessional program, strictly a paraprofessional and a lawyer. So you can imagine, you know, we had like a family law practitioner on the paraprofessional working group who is excited to have a paraprofessional. The idea is I have a paraprofessional or two in my firm. Ultimately, the idea was those folks would be able to form an ownership partnership. So this is very limited to a paraprofessional and a lawyer. The regulatory sandbox, which we also have slides on, is much broader because that's where you get into the partnerships with technologists, other folks that are not in your firm with you doing work with you. you're building a platform together, for example. So the sandbox much broader, this very limited to the paraprofessional and the lawyer.
Interesting. Okay, why don't you go ahead and please continue, and then we'll grab some Q&A and maybe move on to AI, but please continue.
This is required disclosures, so lots of things that have to be disclosed, and then the discipline system. So what was contemplated is a hybrid of the model that exists for attorneys, intake, investigation, and charging done by the Office of the Chief Trial Counsel, but not using state bar court, instead importing the model from the Department of Consumer Affairs, which uses panels. And so it's a hybrid model, and you can see it here. Also addressed is what would be a public record. This, again, a difference from attorneys. There is no concept of private discipline for a paraprofessional. All discipline would be public, and different from attorneys. There is a citation and fine option, which is available in the Department of Consumer Affairs side with doctors and nurses, etc. We don't have that on the attorney side. We imported that into this model. So to answer your question a long way, yes, a fully articulated regulation and discipline structure.
Okay, interesting. Why don't we expand that a little bit into the sandbox? So just to be clear, ladies and gentlemen, here's what I'm understanding. Initially, I was brought to believe that the way this works is a paraprofessional can do everything except trial. And they can take a case from A to Z. I'm not sure how I got that impression. I'm not sure where that impression came from, but I'm sure glad we're having this conversation tonight, because my concern after speaking with Ms. Wilson over the phone was I had an incorrect impression. And again, thank you guys, by the way. I know we didn't do any introductions. We just jumped right into it. Thank you both for taking your time to come and speak with us. It's very helpful. And I'm sure there's going to be a buzz tomorrow. I see my phone's already making noises. I have a feeling this is very helpful for us. So thank you. Let's expand into the sandbox. So the sandbox, correct me if I'm wrong, the goal there was to come up with innovative ways, or come up with different ways at least, to allow legal services to reach the consumer, even if they were produced by non-lawyers. Is that how that worked?
Yeah, if you'll indulge me, this is just 2 slides and it really does cover this topic. So in 2018, so this is separate from the Justice Gap study, the board commissioned a legal market landscape report. And why is the board doing all this work in access? The State Bar's statutory mission is 3-pronged. One of the prongs is to increase access to legal services. So that's why the board is doing all this. So they commissioned the legal market landscape report, and it's a fascinating report. And it shows that what is happening is there's a smaller and smaller percentage of lawyers that's in the individual people market. You have an increasing percentage of lawyers serving business clients, from small business to corporate clients, but not so many small businesses. They also have their own justice gap. But what that means is there's fewer attorneys out there compared to the population that are serving individual clients. So the board commissioned this task force on access through legal services, really designed to look at, should there be any regulatory changes to enhance the delivery of legal services through technology, including AI. That task force issued its final report in 2020 and recommended that the board pursue a regulatory sandbox. Regulatory sandbox, the concept comes from fintech. If you think about Venmo, you think about PayPal, you think about the ability to even do online banking, all of that was tested in fintech sandboxes overseen by the federal government, where financial companies and others are allowed to test new ideas before they bring them fully to the market. So the regulatory sandbox is a concept imported from fintech that has been implemented in the legal setting in various, first in Europe and in the UK and Canadian provinces, then here in the United States in Utah. So the board said, okay, we've got a recommendation to create a regulatory sandbox. In May of 2020, they created the Closing the Justice Gap Working Group to develop the parameters for the sandbox. The 2 subcommittees were formed. One focused on governance, so like the overall governance of a sandbox, and one focused on scope. What kinds of partnerships would be allowed? Questions, for example, does a lawyer have to be involved at all? Let's say the three of us are going to bring a proposal forward to the sandbox for approval. Do any of the three of us have to be a lawyer? Does there have to be one responsible lawyer whose license is on the hook if something goes wrong with the product we deliver? These are the kinds of questions that this committee was asked to explore. Then fast forward, you get Assembly Bill 2958. This bill, the provisions apply to both the sandbox and the paraprofessional program. When you talked about the paraprofessional program being halted, this bill says no action on the paraprofessional program until January 1st of 2025. With respect to the sandbox, it says stop altogether. So they're in two different positions. Prior to the sandbox just shutting down, it completed its work and it posted progress to date on the State Bar website. So you can see all the recommendations that were adopted, draft chapters of the report, and an archive of items under consideration. So they did begin to answer some of these very difficult questions about who should be allowed in. But of course, the work is not completed. So that's the status, and the goal really to focus on harnessing technology to increase access to more people.
Is there, and thank you for sharing that. We'll hop, by the way, guys, don't text me your questions. Please use the Q&A on Zoom. That's what it's there for. I can't keep looking at my phone. We'll do the Q&A in just a second, at least on this, and then we'll hop into the artificial intelligence, chat, GPT, all that good stuff. And maybe you answered this a little, but let me just hit it straight. And I think that's what the audience wants me to do. Under what the sandbox initially was, would it allow non-lawyers to have at least a 49 or a 50 or 51% ownership of a law firm?
Yes, I don't know that the percentage was settled on. I believe the recommendation that they got to was a non-majority ownership. But I don't recall, but I could look for the set of recommendations.
So is there, I guess, let me insert myself here for a moment. A lot of what I do, I do catastrophic injury, I do discrimination in the workplace, and I do abuse, which is elder abuse and child abuse. A lot of what I do is because of businesses that try to cut corners. They don't train their staff. They hire the cheapest person they can. Through my 10, 11 years of practice, I have found something. I've realized something. Corporations are a very interesting thing. They're not real. They're an abstract concept that exists exclusively on paper, and they only have the power that we give them. And the interesting thing about corporations is they're run by humans, they rely on humans, but they're not humans. Again, they're abstract concepts and business structures. And that business structure that's not human, it seems to exclusively, and every plaintiff attorney is about to agree with me on this one, seems to exclusively value increased profit, decreased cost. And there seems to me to be no other standards by which for-profit corporations operate. I understand I'm painting with a very broad brush here. I understand that. But having gone through litigation with large corporations, I get it. McDonald's has Ronald McDonald on the advertisement and it's all chummy. But if you sue McDonald's, they're not so chummy. It's not that. It's a different thing on the back end. It's business people, cutthroat business people. And I wonder, when I point it out like that, and I know I'm not asking a specific question, I'm just kind of giving you a generalized concept. Is there a concern that you're allowing the wolf into the chicken house by saying, hey, businesses, corporations, I get it, there'll be some regulations, but I also get it, lawyers want to make profit too, I get it. But the structure that holds lawyers in place is relatively rigid, I would say, and good, I'm glad it is. It should be. We have access to people's money, we have access to their lives. It should be rigid. We should have those ethical standards. Is there a concern here that allowing the businesses to come in and have an ownership percentage, whether it's 49 or 51%, that you're allowing the wolf into the chicken's roost?
I think that that's a concern that's certainly been expressed by many. I would say that if you look at the regulatory, the legal sandboxes that exist, and you look at what would potentially have been contemplated in California. There are many, many protections against that, including proactive regulation, the requirement to affirmatively report on a number of risk indicators that really are not in place for attorneys. So when you say that the system for attorneys is robust, I would really beg to differ with you. We are a complaint-driven system. There are 250,000 attorneys in California. We receive about 13 to 15,000 complaints a year. Often these are this kind of a group of attorneys that receives multiple complaints. We don't have our fingers on many, many attorneys. You mentioned the CTAP program. That's the State Bar's first proactive regulatory effort, meaning we're reaching all attorneys, regardless of whether or not a complaint has been filed against them. So we don't have much reach at all. And this is different from, a regulatory sandbox. I was wanting to show you, for example, what is required in Utah, what has to be reported, and the kind of data they collect. So I think the point is the whole framework is different in that it is not complaint-based. In order to be in the sandbox, the entities, the individuals making the proposal, and the business structure itself have to be approved. Then there are a tremendous amount of reporting requirements and active monitoring associated with being in the sandbox. So I don't believe that the sandbox itself presents a risk. That is a highly regulated, monitored environment, just like the environment that brought you Venmo. I think it's true that once you said, for example, which the state of Arizona has done, no sandbox, just elimination of Rule 5.4 altogether, no limitations on ownership without the construct of a sandbox, and no particular affirmative regulatory reporting requirements, I think that that is potentially risky, but that is never what was contemplated here.
So you're not offering the Arizona model, you're offering a more stringent one that requires a self-reporting that lawyers themselves don't have to do.
Yes, an extensive amount of reporting. And I will share this because I really encourage people to look at what Utah has done. So every month they produce this report. And this is the report on their Office of Innovation from the office that oversees the sandbox. So you can see the entities that are authorized, their reporting data, the services provided by innovation level, because they rate it. Some are not very innovative, some are very innovative. Services by legal area, consumer complaints, and quality assessments. So they're looking at all of this. Then they have their metrics, applications received, recommended to the court for authorization, all of these things about the applications. But then you can see here, key risks and trends, no complaints, entities reporting data. So every month they're generating this report for the public. You can see the activities being provided. You can see the services by legal area, and you can see there's all kinds of data. So to date, entities have reported 14 complaints, 1 complaint per 3,634 services delivered. So this is the kind of data that's being captured. And these are the harm types. This is also data we don't have for attorneys. Inaccurate or inappropriate legal result, fails to exercise a legal right because they got bad advice, or purchases an unnecessary or inappropriate legal service. We just don't have this kind of exposure or visibility on attorney services. So it's difficult for me to say that the status quo is somehow meaningfully or materially more protective than a sandbox environment where we allow some entities to come in and test new business models in a highly regulated manner.
Okay, so I'm tempted to, in the last 15 minutes on this before we hop into the AI stuff, I'm tempted to hop into the Q&A. I think where the question comes from for me, and I consider myself to be a microcosm of the WBA's constituency, is the enforcement mechanism. And to be honest with you, it's not just me. We have a question in the Q&A. So, and Ms. Wilson, I know it wasn't you who had oversight over the Girardi matter. Let's just make something clear here for the audience. The people who had oversight with Girardi, they're not at the State Bar anymore, right?
That's right.
Okay, so let's just put that out there. Don't juxtapose Ms. Wilson with Tom Girardi. That's not necessarily the case here. So let's just put that out there first. Nonetheless, even that being said, I can't help but hear the voices in these questions, and the questions were always they couldn't regulate Tom Girardi. How are they going to regulate this? And look, everyone has seen business practices, whether by lawyers or otherwise, that may not meet some ethical standard or another. And it is somewhat impossible to regulate everything. I understand that. But I'm just going to go, look, there's a question right here. Is how can we trust the state bar to enforce this? We have bankruptcy petition papers who under federal law can only charge $200 that charge much more and essentially practice law without a license, and the state bar has done nothing. Are you familiar with this bankruptcy petition preparers? Excuse me. Are you familiar with that? If not, I'm happy to ask the question generally. How is this going to be enforced by the state bar?
I think it's a very fair question, and I'm not going to make any excuses. I mean, we released a report outlining really massive corruption, right? Tom Girardi was paying off state bar staff. So there's nothing I can say that's going to justify that. That being said, what was contemplated was a sandbox that would allow a limited number of authorized entities to test innovative solutions to increasing access to legal services. This was not opening up the floodgates, a free-for-all, anyone and everyone who wants to start a business. You could contemplate 3 to 5 entities being approved in the first year, perhaps another 10 in the second year. There would be fees assessed to support the regulatory structure, which would be quite involved. So that's what was contemplated. And so that's all I can say. There is, I think this question can be asked vis-a-vis everything. I know we're going to go into AI and like, what is a fair question? What are we going to do about it? Our ability to move forward as an agency and to ensure that we are effectively realizing our mission of protecting the public is dependent in part, not on people trusting us per se, but giving us a bit of latitude to say this: we did voluntarily disclose the ugliest of an ugly history. And we did that because we are trying to message that we are a new organization. And we've got to be able to move forward on increasing access, on appropriately regulating new technologies like ChatGPT that's currently unregulated. We can't just stay stuck in, we really screwed up with Girardi, or we're really screwing up with bankruptcy preparers, so therefore we can't do anything, we can't progress. That doesn't serve anybody. So that would be my response. I think I have heard of the bankruptcy preparer issue, and I believe that the chief trial counsel, who's over attorney discipline, is addressing that. It's ringing a recent bell with me.
Okay. Let me ask another, this is a good question here. How does the bar intend to protect low-income individuals who are inherently vulnerable already from paraprofessionals who will take advantage of them? We have already seen this issue in the context of immigration with so-called notarios who are notorious for taking money from immigrants.
Well, as I shared when I kind of went over in a hodgepodge manner the paraprofessional slides, there are a number of protections built into the program, including disclosures and a requirement that paraprofessionals report on the fees that they charge. So there are a number of specific provisions around the unauthorized practice of law, including recommendations for statutory changes to increase enforcement against UPL. That was also part of the paraprofessional package. That being said, I do personally encourage a bit of thinking about the labeling of people who are low income as being vulnerable. Because you're low income does not mean you aren't intelligent. It does not mean that you are unsophisticated. It does not mean that you're not able to determine, I can hire Daniel and I can pay this amount for a full scope representation. And then I go to Jennifer, she can't give me full scope representation, but she's trying to charge me the same amount as Daniel. Just because I'm low income doesn't mean I can't use my common sense to determine that I'd rather hire Daniel than Jennifer, who can do the full scope for the same price. So I think there were a number of protections built in, but I encourage us to consider the kind of paternalism I think that does come from broad brush statements that everybody that's low income or everybody that's an immigrant is vulnerable. And the other message there is they're not sophisticated and can't make good choices for themselves. So that's how I would respond to that.
Okay, and I don't think the question was intended to point a finger at low income and suggest these people are incapable of making those discrepancies. I was born and raised in Beverly Hills. I've met a lot of rich idiots, so it's not lost on me that finances are not necessarily indicative of someone's intellectual acuity. But what I would say is, you know, I have had clients come to my office. I am one guy in particular, had a British accent actually. And he was being led on by someone who I assume was a paralegal. This is years ago. And he blew his statute of limitations. And he came to my office for help. You know, I don't know whatever happened with him. I don't know what happened with the paralegal who was helping him. I would say, is it possible that certain people, especially if you're not from this country, I'll think like my grandmother, for example. My grandmother pronounces, you know, the word windshield, and she doesn't, you know, English is not her first language. She's not going to have an easy time reading all this. And to be frank, I already think I know what your answer is going to be. It sounds like there are some baked in protections, i.e. they have to consistently advise the person that they're not a lawyer.
Right. They have to consistently advise them they're not a lawyer. In fact, one of the disclosures, that's what I was looking back at. One of the disclosures has to do with explicitly stating that free or low cost services may be available to you. So like, you may not need to hire me. You may be eligible for a free lawyer. So there are a number of areas where that is baked in. Is that going to prevent the unscrupulous individual from taking advantage of people? No. I mean, I have to be honest, right? If you want to, whether you're a lawyer or not, if that's the kind of human being you are going to find some victims, unfortunately. And there we have to say, again, we've got a lot of people who aren't accessing legal representation at all, millions who do not qualify for free legal aid. What is our answer? You know, we have done the analysis of how many more lawyers we would need just for the legal aid eligible to be fully represented. 13,000 more legal aid lawyers. We're not even talking about this other population. I just don't know what the answer is. It's not going to be pro bono. It's not reducing the cut score on the bar exam. So I think that's the challenge. Yes, there are risks, but what is the risk associated with the status quo? That is what I would ask.
I think that's actually a pretty decent response. Let me add, this is another one of the things that I hear floated around, and it's one of the questions that we have. Are there any private businesses, tech companies in particular, that are sponsoring the paraprofessional program? If so, do they plan to step in once a program has been approved? And let me loosen that question. Let me open it up a bit, give it some breathing room. I think sponsoring the paraprofessional program is a tough way to look at it, but there is talk, Ms. Wilson, about, oh, well, you know, there's a lot of Silicon Valley interests that want to turn law into Amazon.com. They want to turn law into these types of things and provide this corporate product of questionable quality relative to an actual lawyer. Is there, and I've heard, you know, I don't know what's true, I don't know what's not true, but I have heard there are people who might have Silicon tech or tech money behind them involved in these programs. Is there anything to that? I'm not saying it's inherently a bad thing, but is there anything to that?
No. There never was. There was a resolution passed with the paraprofessional program that specifically stated that no funding could be received from technology companies to support that. Now, supporting the paraprofessional program is not a natural fit for a technology company. That would be more like supporting the sandbox. There was no money offered or supported. So the answer is no. Were there some technologists on the Closing the Justice Gap working group? Absolutely. I think we'd be remiss if we didn't have anybody on that working group that had any work experience providing the kind of technological solutions that were being considered. But there was no financial support. And because that was such a hot button issue, there were explicit resolutions adopted precluding that kind of financial support with respect to at least the paraprofessional program. I don't believe the sandbox got that far.
Okay, so just to be clear, at least the paraprofessional program, there is no tech involvement necessarily. However, with the sandbox, there was. I'm not saying that's necessarily a bad thing inherently, but there was some kind of tech involvement in terms of moving that forward. Is that fair to say?
There were technologists on the working group. That's what I would say.
Okay.
Yeah.
Okay. And is there, before we move on, is there, and look, here's the thing. People say things, oh, it's just Silicon Valley money, blah, blah, blah. I don't think the state bar is blind. I'm sure you guys would be aware and open to the idea of, oh, maybe there's some greedy tech billionaire who wants to just like come in here and ravage the legal system for his own gain, not so much for the to increase access to justice. Do you have any sentiment that there is in fact some type of, I'm not saying threat, but at least tension there in terms of tech money being involved? I can certainly also appreciate the benefit of it. I mean, if we're going to have a sandbox, tech's going to be involved, so you can have tech people involved in the hearings and the meetings. Of course you are. Is there, on the other hand, to kind of quench the thirst of the questions that I know people want answered, is there a tension between allowing those tech companies to be involved in the sandbox and what is ultimately best for the consumer?
I don't know. I will say that I think I've heard a lot of concerns. Facebook's going to take over the practice of law, or Walmart. I think there very easily could have been a prohibition against companies with any market capitalization value over X, any multinationals, from participating in a sandbox. So I think there are certainly ways to prohibit the very large global kind of businesses that perhaps do pose an existential threat to the practice of law from participating at all. So that's what I would say. Number one, you do not see them in Utah, and you don't see them in Arizona. So I just want to say that even in Arizona, completely deregulated.
Interesting.
So then we take that group out, and we're talking about a sandbox. I would never advocate again for the model of just changing the rules without a sandbox. So you're talking about a very limited number of entities that you would allow to try to innovate. I can't imagine doing that with no technologists, because I have to say, I think if there had been more technologists involved in the delivery of legal services for the last 100 years, we might not have 2 million people, Californians, sitting on the sidelines, can't afford a market rate attorney, but do have some money to spend. That doesn't make any business sense. If I'm a lawyer, I want to try to reach those individuals. So partnerships between law and tech make a tremendous amount of sense to me, even if I am a self-interested attorney, right? I'm not saying that the only way to get there is through changes to the ownership structure, but that's certainly one way to incentivize the kind of investment that you need to take services to scale. So I think the concerns, I'm not going to say they're illegitimate. I think you can protect against the Walmarts, the Facebooks, the KPMGs, these big companies that we want to keep out of the business, while still allowing this small to medium-sized technology firm that really has some value to add to partner with lawyers and bring some innovation to the market. It's hard for me to see why we shouldn't at least be allowed to test that.
Okay, fair enough. And by the way, Ms. Selnick, anything you want to add to these topics, paraprofessional sandbox, before we move on?
And let me also, Jennifer, I'm so sorry we didn't introduce her. Jennifer is the Senior Program Analyst in our Office of Access and Inclusion.
Thanks, Leah. No, I think everything was covered very well. I would just say that the results that we've seen from other states and provinces in Canada suggests that these programs and the regulations work really well. Washington implemented a paraprofessional program. They first began admitting paraprofessionals in 2017. They've had one complaint to date. That's a really good track record. I think that these programs have worked really well. And the other thing I would say in particular about regulatory sandboxes is most jurisdictions will actually publish the information specifying an individual's name and the exact scope of their participation in the sandbox. And that's a really good way for the public to make informed decisions about their involvement with these individuals and companies that are participating.
Okay. Look, part of the problem here is the devil's in the details, right? So I would, for example, call on the state bar calls. I'd have my 2 minutes or whatever it is to make a point. Everyone at the state bar would quietly listen. No one, I don't think you guys could even respond to us. And then when you actually went to have the meetings, all the lawyers would get off the call and the meeting. And look, I don't blame, I got off the call too. Lawyers are busy out of their mind as it is. I know how that feels, certainly as a solo practitioner myself. So the idea of getting involved in this stuff to an extent can be tough, but then that creates a distance between what's happening and what information is available to people, which is, again, thank you both for being here tonight. I think that's the goal, is to try to bridge that gap a little. So for what I'm hearing is, I think it sounds like the paraprofessional program was not necessarily, just based on what we've seen here tonight, what a lot of people were expecting. I think the sandbox, it's reasonable to understand why certain tech companies would be involved in something like that simultaneously. Look, it's not lost on me. It's usually companies that create the problems that I go to solve in the first place. So I could see a tension, I could see a conflict of interest in there. But again, the devil's in the details, and we don't have enough time tonight. We're actually a little bit behind schedule here. So let's move on to artificial intelligence. Now, something I just want to put out there, guys. I think part of being a good moderator is being unbiased, nonpartisan, objective, yada, yada, yada. I personally, on this particular topic, do have strong feelings about artificial intelligence. And it's not just because I saw Terminator 2 at way too young of an age. I actually wanted to share something that I don't know how familiar people are with the advances in artificial intelligence. I just wanted to have this. I have a feeling I've spoken to enough people to know that not a lot of people know this is happening. I'm going to show you guys art that's created by artificial intelligence. Someone said, what does art have to do with the law? It's not the art, it's the artificial intelligence. Let me just share this real quick. Okay. I'm assuming everyone sees this lovely photo of Donald Trump without a shirt. Check this out, guys. Check this out. It's all the presidents, not just Donald Trump. This is, someone went into artificial intelligence and they said, show me the United States presidents as bodybuilders. And this is what the artificial intelligence did. We don't have to hear the music. I mean, look at that, right? It's borderline. We're getting into that uncanny. This is incredible. Look at, look at just the way his chest is done and the shoulders, and his face merges very well into his body. John F. Kennedy, President Clinton, sorry for showing a bunch of guys in their underwear, but that to me makes a point. It makes a point that artificial intelligence, and by the way, how is an artist going to be able to keep up with that? I'm sure we've also heard the music, right? Is anyone familiar with the raps that are coming out? Artificial intelligence is doing rap, and the rap is as good as the rapper's rap. It's kind of wild. And this is just the tip of the iceberg. So, from what I'm seeing here in terms of artificial intelligence, and the conversation that I'm having right now is not necessarily so much consumer protection. I'm actually participating in a little bit of protection of the legal industry. Just like if I was an artist, I'd also be very concerned because of artificial intelligence. So I just want to put that out there. That's my bias. That's my partisan, just so we know going forward. Putting that aside, Ms. Wilson, let's come to you and let's talk about artificial intelligence. Big picture, what are you seeing going on? What's concerning you? What opportunities are there?
Well, I'm going to ask Jennifer, do you think it would be worthwhile for me to go to like the ChatGPT slide? Do you want to, or the legal tech slide?
Sure, I think that would be helpful. And maybe while you're pulling it up, I would just like to frame this conversation a little bit. I understand your concerns completely. On the other hand, I think that if we take a step back and think about the bigger picture, there are some framings that might help. So obviously, legal tech and AI invoke questions about the future of the legal profession. There's obviously a lot of fears about being replaced. On the other hand, for others, legal tech signifies a pathway towards efficiency and potentially a more equitable legal profession, both for lawyers and other legal practitioners, as well as for clients. I also want to stress that legal tech is so much more than AI, and law firms already use it every day. If you all use case management software, that's legal tech. So legal tech isn't necessarily new in and of itself. On the other hand, the scope of services and possibilities are rapidly expanding. And with this expansion, obviously there are legitimate concerns about how to regulate it to safeguard not only the profession, but also consumers. So I'm sure everyone is familiar with ChatGPT, which is not importantly, ChatGPT is not actually legal tech. What it is a chatbot that uses artificial intelligence to interact in conversational ways with human users, and it has potential for legal applications. It is what's known as a natural language processing tool driven by AI that uses what's called lexical search. That means that it looks for literal word matches and it doesn't necessarily understand meaning. So this might sound like the beginning of the end of the legal profession, but I really don't think it is. First of all, ChatGPT's knowledge ends with 2021. We know that ChatGPT 4, which is the latest version, passed the multi-state bar exam, but researchers have agreed that it could not yet pass the more rigorous California bar. So this slide in particular shows an example of ChatGPT's capabilities as well as its limitations. So at the top, I asked ChatGPT about AB 1482. And at first, I thought I didn't provide enough information, but then you'll see at the bottom, while ChatGPT is able to answer the basic question about the law, when extrapolation is required, the conclusion is incorrect. So in its own response, ChatGPT has essentially contradicted itself. The law, again, is correct, but the math is wrong. So it's not able to do this kind of higher reasoning to replace the function of a lawyer or other legal professional. And it would require someone to check and, in this case, correct its work. So I'm happy to answer questions if any arise or talk through some more examples.
Yeah, well, why don't we address these questions to you, Ms. Selnick? So what if I said to you right now, it's April 2023.
Mm-hmm.
How does the state bar envision artificial intelligence being integrated into our practice? What would you say?
Well, that question, I would probably defer to Leah, but I think more broadly, not speaking for the state bar, speaking just in terms of potentialities, there are certain legal tech that have emerged, for example, case text, as well as Lexata, which provide specific functions that support lawyers and legal professionals, but again, do not replace them. So if we think about co-counsel, which runs case text, it's built using OpenAI's GPT-4, which is the same technology as ChatGPT, and it reviews documents. It can include citations to sources. It prepares deposition outlines, searches databases to answer questions. It can draft legal research memos, summarize agreements, extract contract data, those kinds of things. It's founded and run by lawyers. So unlike ChatGPT, it has lawyers at the forefront of its process. It's being used already by law firms and legal aid already. But again, we would never envision that this would take the place of a lawyer. These are efforts that would essentially save lawyers or save law firms time, which could be used toward other more demanding tasks, or it could be thought of as saving the client money as well by cutting down on the number of hours billed. Does that make sense? Yeah.
I would say I may not have as optimistic as a view for Jennifer about the impact on the profession. I think with the advances in AI, we may very well get to a place where lower level legal analysis, so not just this sort of going through the depositions and some of the things that are happening now, document review, but even lower level advice can be generated through AI. I see a couple of issues. One, right now, this is completely unregulated. And I think it's a problem. And when I talk about the state bar needing to be able to both recognize our past failings and move forward as an organization, this is a prime example. Nobody is served by the total and complete lack of regulation in this space. So I think that's one. Two is this: to the extent that lawyers learn how to effectively harness it, and that we promulgate rules that govern how lawyers use these tools, which we need to do, I think this allows lawyers to maximize or increase their own reach. And this gets back to the millions of Californians that have civil legal issues that are choosing not to hire any lawyers at all. So I think it can be an opportunity, not just a risk, if it's harnessed and used correctly and used with the increased scope of reach in mind by lawyers. So that's where I see the opportunity. You can imagine that if you have an AI tool that actually works, that can do many lower level tasks, that will free you up to do more higher level, high billable hour tasks. And that's really potentially differentiated tiers of hourly rates. That is where I think we ultimately may go. But again, I see the current risk being that this is completely unregulated.
Yeah, the lack of regulation is a good point. With all respect to all bureaucracies, I can't imagine any bureaucracy, federal, state, any one of them would be able to keep up with the rate of advancement. So Ms. Wilson, in particular, I agree with what you're saying. I have a feeling the regulation will be a minute late and a dollar short. And that's something that needs to be kept in mind. So it warms my heart to hear that. I certainly, and I know one of the questions out there was, what was the software? It's called Co-Counsel by Case Text. I think it's actually may have already been answered. Let's go into some of these potential applications. You know, there's areas of law, and it kind of comes back to the same topic, doesn't it? Who's underserved? Because you know that billionaire corporation has plenty of lawyers. They have so-and-so large corporation on retainer. That's not what anyone's concerned about, I assume. Correct me if I'm wrong. But imagine in the world of wrongful convictions, for example. I'm a big supporter of the Loyola Law School Project for the Innocent. Every time they get someone out of jail who's been wrongfully convicted, it's like a celebration. It's huge, you know, saving lives. Is there applications in particular? Because I'm trying to get into the specifics, because from the specifics, we can start to negotiate the difficulties and opportunities, which is, are there any specifics? So for example, maybe wrongful conviction, or goodness gracious, I can only imagine that the world of criminal justice in particular, I have a feeling public defenders are way overwhelmed. And I don't know how they'd be able to give people all the representation they need when they have 100 cases on their docket. So, and I know I'm bringing up criminal defense stuff, but I'm not purposefully specifying it to that. Is there specific implementations of AI that you can envision, or maybe even you just have a sense of it, it may show up in the future?
Well, I put up on the screen something I'm hoping Jennifer will speak to. I think this is right on point. And then certainly I know that there is an expungement tool as well, but go ahead, Jennifer.
Thanks, Leah. So There's a collaboration between the UC Berkeley Possibility Lab and Oakland-based For the People. They're building a resentencing tool to standardize and expedite prosecutor-initiated resentencing. They've begun piloting with the YOLO DA. Right now, their goal is to reduce the burden on prosecutors to get more people out of prison faster. And their hope is that with YOLO as a positive test case, they can expand to other counties and potentially beyond California. So I think that that's a really good example to address your question. And I have another idea as well, but I'm happy to talk about this one a little bit first.
And then another one I would just mention is Code for America, which has done a lot of work with public defenders' offices to create this automated process for expungement. You may know that the state of California passed legislation requiring the Department of Justice to automate the expungement process. It has, I think it's been very difficult to get off the ground because of the technology issue, but Code for America has been really instrumental and well before the legislation worked to develop a tool. So those these are two examples in this particular criminal justice space that we're aware of.
Outside of criminal justice, is there any areas you'd say, hey, AI in particular could be helpful here, possibly? I'm not asking the state bar to commit to anything, just to be clear. This is a very casually oriented question, which is, do you have a sense, orientation, anything of any other area of practice where AI might be implemented?
So if I may, there's a group at Stanford who is working on a program for text messaging for courts. If anyone here uses an app like MyChart for their doctor, and you receive notifications or text messages that require you to hit OK or yes to confirm that you're going to an appointment. During the height of the pandemic, they asked you to confirm that you didn't have COVID symptoms and things like that. So it's a similar model to that, but it would be much more complex to make a multi-step program that would allow users to not only check in for upcoming court dates, but receive reminders about filing deadlines, notifications when their documents are received, and get reminders about other important due dates. So I think that a program like that, which would use AI, could be really innovative. Again, I think all of this, the conversation about regulation is not lost on me. So that would obviously need to be part of the implementation, but something like that, it's not necessarily very high tech AI, but it could save a lot of people from missing important deadlines and due dates.
So let me bring the questions here. I'm going to bring it to like enforcement and oversight. So let me just read. Someone posted this. I had a client use an AI app to do some important research. Whoa, for me. The result was amazingly on point, exclamation mark. Seemed like a game-changing research on point with citations. Then I checked the citations and they weren't even close. Non-lawyers doing legal research is always an interesting endeavor. I doubt a pro per litigant could plead ineffective assistance of AI counsel. That's kind of funny. And then let's follow that up with this other one. Who is liable when the attorney delegates task X to AI and AI does it wrong? So I brought those both together to give kind of an amalgamation of a sense of really a quandary here in terms of enforcement, regulation, oversight. Does the state bar have any sense of any of that?
Oh, we have a sense that it's a problem. We do not regulate entities aside from registration of LLPs and law corps. We don't regulate entities. So that's problem number one. No, so I think even beyond the state bar, there is no single entity that's responsible for regulating these kinds of products or these business structures. And that is a gaping regulatory hole that somebody needs to address. So that's one problem. The other issue, the lawyer use of the tool. What I have understand from talking to my ethics experts, which I am not an ethics expert, is that if you piece together a number of state bar existing rules of professional conduct and comments to those rules, you can get at what you're supposed to do and what you're responsible for reviewing and not reviewing. I think it's insufficient. And so I do think we need to promulgate rules that make it really clear how lawyers can use the tools. And in the absence of the state bar acting, I am aware that in law firms, you said they won't need to use it. I think that they are, big law. They're issuing their own internal guidance about how associates can use the tool, who needs to review what. So this obviously, is really critical that the state bar steps in. And here, that's an area we can act, right? We cannot regulate entities, but we can certainly promulgate rules of professional conduct that are on point. And I think and expect you'll see us move in this direction soon.
Yeah, it is an interesting thing, and I think it implicates not just our practice, but frankly, the world as a whole. And again, there's a reason I showed those photos. I was stunned by the quality of AI artwork. It looks like AI is coming for the artist first and foremost. But I remember someone said this, I don't know who this was, some computer data scientist person I heard somewhere. And I said, to explain AI, it would be like this. Imagine I ask you a question and I gave you 100 years to answer the question, or at least think about the answer, I should say. And you could read at it, effectively, you're not even reading, you just text is put in front of you and it uploads to your mind, and your mind is unlimited in terms of storage. It can go through 10,000 pages and take context from one place and footnotes from another. It can do all this, and then it would answer the question, except in real time, that would be about a second for the machine. It would take us 100 years and it would take us brain power that we don't have, and the machine does it in 1 second. And that's just today. Who knows what happens tomorrow? So I certainly think, and I think it's pretty obvious how I feel about artificial intelligence. So it is, and I'm heartened to hear that the state bar seems to share some concerns with this, because I think there's other arenas where the notion of artificial intelligence, the gas is just being pushed and we don't know what's going to come of it. So that's nice to hear. In terms of, do you guys foresee, and I know you guys don't regulate insurance or malpractice insurance and things like that, but do you see this going to the point where attorneys who use artificial intelligence will have to have some kind of an additional ethical oversight, or maybe a specific malpractice insurance of some kind? Or do we just say, hey, look, the lawyer is responsible, so nothing really changes?
I don't know. It's a good question. I certainly don't think we've gotten that far. We have assessed the issue of mandatory malpractice insurance with, a lot of bruises about 5 years ago. So I'm not sure that's something we're going to take up. But as I said, we do need to promulgate rules, and maybe as part of that process, the issue of insurance will be raised again.
Interesting. Okay. Not a lot of Q&A for the Q&A that's left over is back to the paraprofessional stuff in the sandbox, of course. Guys, give us your questions on AI. Maybe it's just a significantly less controversial topic. Let me for a moment, I would not be a good president if I didn't do what I'm about to do right now. Just take a quick, and I know I didn't ask you guys to prepare for the CTAP, so it's not going to be a super in detailed question but I can tell you this. I remember the first time I learned about the CTAP, I was watching the seminar, and I got a horrible sense of anxiety, and I thought to myself, that's just me, whatever, I'm hard on myself. Okay. And then the WBA did a CTAP seminar, and my phone was exploding with people saying, I can't, they're using expletives, so I'm not going to repeat them. But terms like scary, terms like, oh my God, terms like, I'm going to stop being a lawyer, this is too much, sort of came up. And I look, there's always initial shock, right? There's always the initial shock. You jump in the ocean, there's a shock because it's cold, but then you warm up and you realize it's fine. I will say there was one area in the CTAP in particular, which I think on an objective scale, not just subjective scale, but an objective scale, posed some issues and could get messy. And I'm actually not even going to ask for you guys to get into the details on that. I'll tell you what area it is I'm talking about, just so I'm clear. And in particular, it's the reporting or paying out of settlement funds subsequent to receiving the money. And in the arena of personal injury, that could get very complicated. After Tom Girardi, certainly I can understand why the state bar would have a vested interest in making sure clients get their money. I don't disagree with that. But some of at least as I understood the language, and let's be clear, what we're kind of realizing tonight is just because I hear something somewhere doesn't mean it's necessarily true, right? But at least as I understood the language, I could see things getting messy when you have, for example, a client who has, let's just say, $100,000 settlement. The lawyer has a fee, there's a lien, there's a Medi-Cal lien, there's a this, there's a that, and you're trying to navigate all of this. And the CTAP seems to have requirements, timing requirements for informing this person, paying this person, informing this other person. That could get messy. I'm not going to ask you to comment on that because, again, I didn't give you the opportunity to prepare for it. I didn't know we'd have the time for that. What I will ask, though, which is a very generalized question, is how does the state bar see the CTAP enforcement going, at least for the first year or two? Because, of course, every lawyer and their mother is now saying, especially the personal injury ones, I'm in the middle of a lien negotiation with Dr. X. I have a Medi-Cal lien from this or that, or maybe even we did videotape deposition. I need to pay back the deposition companies based on the settlement. And now, I need to let the client know I need to pay out to this person. I have so much time to pay out the client, but I haven't finished my negotiations with the doctors yet. So am I going to pay the client, negotiate with the doctors, and whatever money is left over, pay the client the rest of it? It can get laborious. And it seems to me like it could be, assuming I understand it correctly, a malpractice trap. How does the state bar expect to enforce the CTAP full power in the first year or two of its implementation, or is there kind of a soft opening to it?
I think it's fair to say there's a soft opening, but I would want to clarify this. You're talking about amendments to the rules of professional conduct that were part of the CTAP program writ large. That's the new requirement, the timeline for distribution of those settlement funds. And making explicit that the receipt of settlement funds is a significant event triggering that client communication requirement. So those rules were adopted under the broad auspices of CTAP. When you talk about CTAP and enforcement, I think a lot about the requirement that you all have now to report to us, not just on your IOLTA accounts, but your individual client trust accounts. So what I can say is this, that the CTAP program, particularly the reporting requirements, are being monitored by our regulatory arm, not our disciplinary arm. What we're enforcing now is simply, did you comply with the reporting requirement? Okay, we had about 96% of attorneys did. We have a small percentage out there who has not complied. They will be given multiple opportunities to comply, but at some point, if they don't comply, there will be administrative action taken against those attorneys, not disciplinary. Then you get into the enforcement of, for example, the rules. That's going to happen the way that rules get enforced now. The vast majority of that happens through complaints that are filed with the Office of the Chief Trial Counsel, and they are investigated. I am not over that process, and I cannot tell you how the Chief Trial Counsel intends to enforce the new rule vis-a-vis complaints that come in. It is a new rule. It's a fairly nuanced rule. I don't expect to see a tremendous number of client complaints come in about that rule, but certainly not in the first year. But I can't respond to that. Under CTAP, there are proactive audits contemplated. That's another time that you may see this come up. Those are most certainly not being implemented for the first year. I don't expect the full scope of auditing to be implemented for 2 years or more. First of all, the program is not fully funded to do all of those steps. So that's my long way of saying the reporting in the first instance, yes, that's being enforced. You have to report. The complaints for rule violations, those will be addressed the way rule complaints are addressed. Proactive auditing, where we might also catch a rule violation, is not underway at this time, and it is not fully budgeted. And so I think it's safe to say 18 to 24 months before we would see a full scope audit program in place.
Okay, I mean, look, it's good to hear. I wish we had you at the CTAP program. I understood why lawyers felt anxiety as they went through the program. I felt the same anxiety. But I also appreciate that again, the devil's in the details, and ladies and gentlemen, it's why we have Miss Wilson here, right? We could dance around and we can get secondary sources, and that's not a bad thing. That could be a very good thing. But going straight to the state bar is a lot better. And that's actually why I called and I asked. I said, hey guys, can we please speak with you? I think there are some communications here that are worth having. And by the way, let me just throw this out there. No one needs to commit. I would love to do this every year to have you guys come on board and explain these things and break these things down, because I see the comments. We're going to do in May 18th, the WBA is going to be doing a mixer. It's going to be at the Sofitel Hotel. We're going to get the invite out tomorrow now that this event's done. I can guarantee you, despite that we've had this event, people are going to come up to me and they'll be like, hey, how about that paraprofessionals program? They're ruining. There is a need for this type of communication. And I'm sure part of you guys, you're pulling your hair out saying, look, we put all the information out there. You can call into the state bar meetings and listen to us. I think the discrepancy is, you know, the lawyers are so just stressed and busy as it is to add sort of, I wouldn't call it extracurricular. This is incredibly important, but to add this on top of what the lawyers already do is tough, which is again why it's nice to have the executive director of the state bar just come on Zoom and answer questions. It's directly gets to the point. So I appreciate that. I'm trying to get to the Q&A here. Let's try to keep the Q&A on topic, my friends, though appreciate the comments.
I know. I will, like, wow, you're a hero.
The CTAP thing was a thing. I knew the moment the seminar was over, my phone was vibrating and people were truly anxious. And here's, earlier I brought up a point. I said, there are lawyers who feel like the state bar doesn't have their back. And let me add some meat to that, just so you know what I'm talking about. So Tom Girardi, who, by the way, in full disclosure, I don't know if you guys know, it was my podcast he was on prior to the lawsuit. 3 weeks prior to him getting sued, I published a podcast with him, and that's how I got embroiled into the whole Tom Girardi thing. So I'm somehow intimately involved with this now. But I'm happy to say it. The guy's a criminal. He's truly a criminal, truly a bad person. I sat across him, didn't have any idea. I was fooled and charmed, frankly, by his demeanor. And I think what happens is you look at someone like Tom Girardi, who's a criminal, and you look at the state bar, which in a sense participated in that criminality. At least it was a violation of ethics. I don't know if it was crime. And then you say, well, geez, that sucks, because 99% of lawyers such as myself are just coming to work and trying to do good work on behalf of their clients. And it's tough work. It's tough work. There's a reason my hair is turning white before I'm 40. It's tough work. You know, I get it. And then the lawyers see from that amalgamation comes now more regulation for the lawyers. Now comes more requirements for the lawyers. And I think the internal sense is, well, look, you had one bad apple, and then there's other ones, no doubt, but you had a bad apple and you had a bad regulatory system. And what came out of it? More regulation by the regulatory system, which failed to regulate the bad apple. And again, let's just be clear, ladies and gentlemen, Miss Wilson was not part of this Tom Girardi stuff. The people who were there during the Girardi era are gone, just to be clear. So don't throw it on her neck. But the reason you're seeing the comments about my alleged heroism is because the constituency does feel this. And I wanted to convey that to you guys. Maybe you already know, you probably already do. So I might be beating a dead horse here. But there was that. So it's nice to hear that, at least insofar as enforcement and things of that nature with the CTAP, there is some hesitation, you know. Anyways, let's see if there's any other questions in here. Guys, please try to keep the questions as professional, because I have to read these in real time.
Well, while you're reading, I will say, CTAP, first of all, we are not the only state to do this. In fact, there are many states in the country. New Jersey has the most robust program that do audit and monitor all client trust accounts. So yes, it is in response to Girardi, but we're not doing something that no other jurisdiction is doing. And the program itself is modeled after something that is in place in both New Jersey, but also Ontario, Canada. And they've been doing it for decades there's a model, there's precedent, both in our country and abroad. So I think that's important to say, when we're looking at shortcomings, obviously we have to look at corruption, we have to look at incompetence, but we also have to look at structural kinds of reforms. And so implementing a CTOP makes a lot of sense in that vein. I will also say that we've tried to be really clear, one, by not housing it in our disciplinary function. Two, providing all the trainings and all the material that's online, and that will only keep accelerating. We try to make it clear this is not a game of gotcha. Our goal is compliance. We believe that the vast majority of those who are not in compliance, it's because they don't know how to be, or they don't have the tools to be, not because they are trying to or are stealing client money. So really that is our belief. So, I'm not going to say we have attorneys back. We are a regulator and we are here to protect the public, but we are trying to support compliance, not trying to do a gotcha game with attorneys who made a mistake or aren't doing it correctly, but they're not stealing anybody's money.
It's good to hear that, Ms. Wilson. And again, just to say the thing I've said now twice before, it's good to have you guys here to break these things down. Let's we actually have an AI question in the Q&A. And I think we all know what the answer here is going to be, but let's present it to the state bar. Do you think lawyers will be able to start citing ChatGPT in arguments, oral or written? And not just that question, open it up if you wish. Do you think there's something there in terms of citation, reliance on ChatGPT? And I'll just remind everyone, there are lawyers who rely on secondary sources, right? There are lawyers who cite secondary sources. And correct me if I'm wrong, I don't know if I got this one quite right, but I do believe there was a case long time ago, and in fact, I think I met the attorney who did it through the Westside Bar Association, which made it such that there's precedent that suggests you can't use the Rutter's Guide, for example, as a source in and of itself. You can source the sources within the Rutter's Guide, but I'm not sure the Rutter's Guide itself can be a source. Don't quote me on that. That was a long time ago I heard that. So what does the state bar have to say in terms of relying on ChatGPT as a source of information in court?
Yeah, I don't have anything to say tonight. As I said, the discussions we've had internally, I understand that our folks believe that the current rules, if you piece various rules together, do speak to the myriad of issues associated with lawyer use of AI. I think we also believe that the current framework is insufficient. So that's all I can say. I can't speak to citation in court.
Okay, I understand that. Here's another question. In terms of the people who were on the state bar, and look, if you can't answer this, I get it. I didn't ask you to prepare for this question. In terms of the state bar, the people who were on the state bar at the time of Girardi and were effectively bearing the complaints, is there going to be repercussion, ramification? Is there going to be anything?
Well, we are not able to put people in jail. So I did see the question. I will say, I don't think it's any secret that multiple U.S. attorneys' offices are investigating a host of individuals, including Tom Girardi's son-in-law, who I think is that on both criminal and civil charges. So there's a lot going on, including with some of the individuals that are named in the report that we released. That's not prosecution work that we're involved in. With respect to those who were named who are attorneys, that is an area where I cannot speak. I don't have the ability to self-determine disclosures about investigations, but I will say that all appropriate investigatory activity is taking place, whether by the state bar or any criminal agency. So that's what I can say. I think where appropriate and where the law so provides, there will be repercussions.
Let me specify the question. And again, if you can't answer this, I understand. In terms of the actual people who were, not the lawyers, I get it, Girardi's, all sorts of people around him may have been corrupt. What about the actual state bar employees themselves? Do you know if there are any investigations into the employees of the state bar who participated in malfeasance, moral turpitude, unethical behavior, or outright broke the law?
I think it's not a secret that some of the individuals named in the report, I would say, I don't have my GC here, talking in my ear. So some of the individuals that are named in the report that we recently released, the investigatory report by Aaron May, they are currently being investigated by the Department of Justice. I would really want to look at our FAQ to see which names, I can say, but I would say yes. Other individuals who may not be being investigated by the Department of Justice and who are lawyers may be being investigated now by the state bar. The ability to disclose that information does not rest with me. It's with our chief trial counsel or our board chair. And I do not believe that we have said which particular individuals we're investigating. So all I can say is between the Department of Justice and the state bar, yes, investigations are underway, not just for the big fish, but with respect to the state bar employees themselves that are at issue.
Interesting. Okay. And by the way, thank you for that report. I read it, or most of it. I don't think I read the whole thing, and we posted that in the Westside Bar Association. So your efforts up north don't go unnoticed. We try to share that information. I think tonight's an exemplar of the WBA's efforts to share the information. To my surprise, we're about 8 p.m. We have 15 minutes to go. Rarely is there a situation where I run out of material, but we have touched paraprofessionals. I think it wasn't necessarily what everyone was expecting it to be. We discussed the sandbox and we saw how there is both value and, in my humble opinion, potential tension somewhere in there. We've talked about, I'm just going to close the Q&A at this point. We've talked about see, I've completely lost my train of thought because I'm reading these Q&As. We've talked about CTAP, which wasn't even supposed to be something we were going to talk about. And I really was appreciative of your input there. I think we've kind of covered the gamut, and AI just seems like we're not there yet to really put things down into stone. Again, I invite you guys, please come back next year. Please come back the year after that. This is so critical. And I think if we keep doing it, these events will get bigger and bigger, and maybe other bar associations can get involved. Allow me to ask these questions directly to you right from it. So let me switch this around a little bit and say, and this is something you mentioned on the phone call with me, Ms. Wilson. Is there any questions the state bar has? Is there any input that you're looking for from the legal community? Is there anything in particular you guys are saying, Daniel, we have these conversations and we always wonder X, Y, Z. Is there anything that we could provide input on?
Well, I'm sure the answer is yes. What I want to say first is I really thank you. I think you're a very open-minded moderator. And certainly when talking about the paraprofessional program or the sandbox, I haven't had such a what I feel is sort of a neutral experience. So I appreciate that very much. You've given me an idea tonight for something that I think we should do, which is about a year or so after implementation of the rule that you were referencing that requires the timely distribution of the settlement funds, to convene some focus groups with attorneys that do this work, are impacted by the rule, to hear about how it's actually working in practice. Does the rule need to be modified or amended? I think that we need to be open to that and create that kind of dialogue with practitioners, because again, the goal is not to create opportunities for people to fail. So I think that's one that I will take you up on after I go back and talk to our team and maybe ask you to help put together a group of lawyers. So that's one that comes to mind immediately. It's been a long day, so I don't have a lot of other brilliant questions at this point, but I appreciate very much the opportunity to present here tonight.
Thank you, Ms. Wilson. Ms. Zelnick, any closing thoughts?
No, just thanks for having me. It's been a pleasure.
Okay, truly, guys. This has been an experience for me. I am the moderator, but I'm also one of your constituents. And thank you for your kind words, Ms. Wilson. Our goal here is to shine light, not to create controversy. And I'm happy we've done this tonight. I'm very happy. Again, the invitation is open. In terms of any focus groups, whether myself, another WBA board member, or any of our community can be involved, let us know. We have a Facebook group with 2,300 attorneys in it. So we just posted and they're all there. So anything that we can do to get the word out in that sense, we have more of a social media presence rather than email presence. So please let us know. I think the state bar working with the lawyers and lawyers working with the state bars where the future is at. So unless anyone has anything else to add, ladies and gentlemen, thank you so much for taking time out of your evening. This is incredibly important. These are the topics that we always see in the Facebook group that you guys talk to me about at the mixers. You know, here it is, straight from the state bar. I think a lot of the information was enlightening. I think we heard things that we didn't necessarily expect to hear. I think part of the reason we're ending early is because there was less controversy than we expected there to be, right? And that's a good thing. I'll take that any day. So ladies and gentlemen, Miss Wilson, Miss Selnick, if you don't have any closing words, I'll just wrap this right up.
All right, thank you.
All right, guys, please join the WBA Facebook group. It's free. There's no membership costs. Our events are mostly free. And we try to give you a quality of MCLE, a quality of seminar, and a quality of mix so that you just don't find in other places. If you're not in the Facebook group, you should be. If Facebook's not your jam, no problem. Go to our website. Sign up for the email list. My name is Daniel Fruzen, founder and president of the Westside Bar Association. Happy to be here tonight, guys. Thank you so much, everyone, for your time.
Good night.